morning. How's everybody doing? Great to be learning with you on a Thursday, Yom Hamishi. Let's light up the darkness. Who's in the house? Stephen in New Hampshire, Yehud in South Carolina, Paul in the Great Northwest, Melissa in Great Neck Bell in Florida, Guy in Ohio, Joe in the Inland Empire, where'd he go? Shandora in the Bronx, Bill in Mid-Missouri, Belle in Texas, Sharon in New Jersey, Lorraine in Texas, Lucy in Minnesota, Chaim in Florida, Aoife in Florida, Marjorie in Georgia, Nella's in the house. Welcome, everybody. Doubled off. It took us many weeks to get through Mishna number 4 in chapter 3, but today we're going to open and complete Mishna number 5 and get into Mishna number 6. We picked this up near the bottom of page 56a. And we do have a double daf. Mishnah 5. If there were two witnesses testifying on his behalf that he, the possessor of the land, worked and profited from a field for 3 years, and therefore he has presumptive ownership. This is a topic we've been on for a while, right? So somebody purchased a piece of land, and then somebody comes along and says, hey, that's my land. What are you doing on my land? So this guy says, hey, I purchased it from you, or I purchased it from the prior owner. I don't know who you are, or I purchased it to the guy you sold it to, but I purchased it. It's my land. Okay, so he's going to have to prove it. Maybe he doesn't have the deed. Maybe he lost it. However, if he's been there for 3 years, working, benefiting from that land, then he has established a presumption of ownership, and the one who's coming and making the claim, he's going to have to prove that the guy who's on the land doesn't belong there. That's what the presumption of ownership really is talking about, is who has the burden of proof. Today we're going to be talking about, okay, well, what about the witnesses? Right? If you're going to say you've been there for 3 years, you got to prove that. And what kind of witness testimony is sufficient to prove that? So, if there were two witnesses testifying on his behalf that he, the possessor of the land, worked and profited on that field for 3 years, and therefore he has the presumption of ownership, and those witnesses were found to be conspiring witnesses, liars, right? So the Torah has this very specific law about conspiring witnesses. Every matter that's established in a court of law, pretty much every matter, is established by the testimony of two witnesses. The Torah says 2 or 3 witnesses, but minimum 2. So if you need 2 witnesses, okay, then they come, they testify, and then it turns out that they're liars. Now, how do we establish that 2 witnesses are liars? Because 2 more witnesses come and say what? Not that they have a different version of the events that the first witnesses are testifying to. In other words, you could have 2 people saying that there was a car accident and the white car hit the black car. And then 2 other witnesses come and say, well, we saw that accident, but it was the fault of the black car that hit the white car. Now, they're going to have different versions of the events. Doesn't mean they're liars. You know, people can see different things, especially if they were standing in different places. That's not conspiring witnesses. Conspiring witnesses are 2 people come and say, we saw the white car hit the black car. And 2 other witnesses come and say, well, you couldn't have seen the white car hit the black car because on the day and time and location where you claim that you were standing there and you saw the white car hit the black car, we saw you in another city, miles away, right? So these people are liars because they never could have seen what they are claiming to see. And there's 2 witnesses who come and testify that they are liars. Now, if that happens, if 2 witnesses are established as conspiring witnesses, witnesses who colluded to lie in a litigation, what is the punishment? They are going to receive the punishment or the liability that the defendant would have received if the testimony of the conspiring witnesses had been believed. That's a heavy penalty, as it should be. We're going to take very seriously if witnesses come forward to a court of law and lie therein, and by their testimony, for example, if they were testifying in a capital case that the defendant committed murder, and it turned out that the witnesses were conspiring witnesses and they were lying in order to have the defendant executed, then the conspiring witnesses would be liable to execution. Or if they were just coming to conspire and say that money should be extracted, they're going to have to pay that money. So here, when we're talking about presumption of ownership of a piece of property, a field, a house, etc., we're talking about monetary cases. And if they're found to be conspiring witnesses, they are going to be liable to pay what the defendant would have had to pay, right? So here we go. In this case, he would have had to give up his land, so they will have to pay the value of the land. All right, let's go. So if two witnesses were testifying on behalf of this guy, saying that he's been residing there for 3 years, and then they were found to be conspiring witnesses, as it was proven that they were not present to witness the matter about which they had testified, so they must pay to the true owner of the field the full value of the field that they attempted through their testimony to remove from his possession, remove from the possession of the true owner of the field, right? They're conspiring with the guy who claims he's been living there for 3 years. So now they're going to have to reimburse the owner of the value of the field. Now, this is interesting because now that they've been found to be conspiring witnesses, the guy who's been living there for 3 years, he says, well, he hasn't proven that he's been living there for 3 years. So presumably the field goes back to the true owner, and nonetheless, the conspiring witnesses are also liable to pay the value of the field. The full value of the field that they attempted through their testimony to remove from his possession. As it is written in the Torah, Deuteronomy 19:19, then shall you do to him, the conspiring witness, as he had planned to do to his brother. If 2 witnesses testify that he worked and profited from the field during the first year, and another 2 testify that he worked and profited from it during the second year, and another 2 witnesses testify that he worked and profited from that land during the third, and all of them were found to be conspiring witnesses, then payment of the value of the field to the owner is divided among them, right? So in this case, there was a pair of witnesses for every one of the 3 years, so each one is going to end up splitting a third, so each one is liable to a sixth. So, continuing the Mishnah, now we're on page 56b. If the testimony was given by 3 brothers, each of whom testify about one of the 3 years, and another unrelated individual joined with each of the brothers as the second witness, these are 3 distinct testimonies, and they are accepted by the court. If they were to be considered one testimony, well, then the testimony would not be accepted, as brothers may not testify together. You can't have 2 witnesses where the 2 witnesses are closely related to each other. That's like only having 1 witness. But they are one testimony for the purpose of rendering them conspiring witnesses, and the payment is divided among them. In other words, there were 3 brothers, but each of them is saying, I saw him living there for 1 year. The next brother says, I saw him living there the second year, and the third brother says, I saw that guy living there the third year. Now, those 3, each one of them is only 1 witness for that year, but each of those 3 is combining with another witness who's not related to them, who says, I saw that guy living on that property for all 3 years, right? So that's why the 3 brothers, they're not testifying together. Each one of them is testifying about one particular year. Within that year, each of those brothers is combining with this unrelated third party. Now, if all 4 of them, right, the 3 brothers testifying about 1 year each, and the third party who's testifying about all 3 years, if all 4 of them are found to be conspiring witnesses, so then as a group, they're going to have to pay the full value of the field to the true owner. So that unrelated party, he'll pay half of it, and the three brothers will split the other half. That's the Mishnah. Now the Gemara. The Gemara notes the Mishnah, our Mishnah that we just read, is not in accordance with the opinion of Rabbi Akiva. As it is taught in a Baraisa that Rabbi Yosei said, when Abba Chalafta, who was Rabbi Yosei's father, went to Rabbi Yochanan ben Nuri to study Torah, and some say it was when Rabbi Yochanan ben Nuri went to Abba Chalafta to study Torah. So he said to him, what is the law if there is one who worked and profited from a field in the presence of two witnesses during the first year, and then in the presence of two other witnesses during the second year, and finally in the presence of two other witnesses during the third year? And he said to him, this is sufficient for establishing the presumption of ownership, because we have pairs of witnesses testifying as to each of the 3 years. So we have, full witness testimony saying that this guy was residing on that property for all 3 years, so we can establish the presumption of ownership for him. Now, the opposite view is going to be Rabbi Akiva. So the latter said to him, I say this as well, I agree with you. But Rabbi Akiva disagrees with regard to this matter, as Rabbi Akiva would say that since the verse states, at the mouth of two witnesses or at the mouth of three witnesses shall a matter be established. So how is this a contradiction? That's Deuteronomy 19:15. But from the wording of this verse, that at the mouth of two witnesses or at the mouth of three witnesses shall a matter be established. So from this one can derive that testimony is accepted only with regard to a complete matter, and not with regard to half a matter. In the Mishnah, although presumptive ownership requires testimony that the property had been worked and profited from for 3 years, testimony is accepted from each pair of witnesses with regard to 1 year. There's no witness in the latter half of our Mishnah that saw the guy living on that property for 3 years. There was a pair of witnesses who saw him living there the first year, a different pair of witnesses who saw him living there the second year, and a different pair of witnesses who saw him living there the third year. We say we can combine all those testimonies to establish that he was there for 3 years. Rabbi Akiva says the law in the Torah is saying that you establish a matter by the mouth of 2 or 3 witnesses as to the whole matter. If you can't bring one pair of witnesses who saw that guy living there for all 3 years, you can't establish that he lived there for 3 years. That's Rabbi Akiva's view. It's the minority view. He was overruled by the majority. Now the Gemara asks, and with regard to the rabbis, meaning the majority that overruled Rabbi Akiva, and who accept the testimony of each of the 3 pairs of witnesses to establish the complete matter, so the combination of the 3 pairs of witnesses, so what do the rabbis do with this derivation of Rabbi Akiva, who says a complete matter and not half a matter? Are they saying that that's just not a principle that we hold by, or are they saying that principle doesn't apply in this case? So they continue the analysis. If we say that this analysis of Rabbi Akiva serves to exclude a case where 2 witnesses testify, for example, that a young female is no longer a minor but has become an adult because she shows signs of being an adult, and that's a defined term in the Talmud. When is a child considered an adult? It has to do with the onset of puberty. We're not talking about an adult, who can make adult decisions and buy homes, etc. Just for certain aspects of the law, when they become obligated in the mitzvahs incumbent, in the commandments incumbent upon a woman. When does that happen? When they hit puberty, and what is that? When they have 2 hairs, right? So in the body. So what they're saying, in terms of seeing these 2 hairs to establish, we're talking about an adult and not about a minor. So if we say that this analysis of establishing a whole matter, that both witnesses saw the whole thing, this would exclude a case where 2 witnesses testify that a young woman has these 2 hairs on her body, and therefore she has reached maturity. But one of the witnesses says she has 1 hair visible from behind her, and the other one says she has one hair visible from in front of her. So they are testifying about two different hairs. We're literally splitting hairs. And in this case, the rabbis say this testimony is not accepted, since they each testify with regard to only half of the matter. Well, if that's what we're talking about, that's what they derived about a complete matter from the way the law is stated in the Torah, then we have a problem. Because this is both half of a matter and half of a testimony, as there is only one witness with regard to each of the hairs. Neither hair was seen by two people. So for sure this testimony is not going to work. And we already know it's not going to work because we can't even combine it. If we said that there were two witnesses who saw one of the hairs and another two witnesses who saw the other hair, then we could combine according to the majority, but not according to Rabbi Akiva. But where we only have one witness to this hair and one witness to that hair, we have half of a matter and half of a testimony. So rather, in the opinion of the rabbis, the derivation serves to exclude a case where two witnesses saw one hair on her front and the other two witnesses saw one hair on her back. Then we could combine the testimonies, and that, right? I'm sorry. Then we still wouldn't combine. In this case, each group of witnesses gives full testimony with regard to half a matter, i.e. one of the hairs, as both hairs must be present concurrently in order for her to assume the status of an adult. By contrast, in the case of our Mishnah, the years are by definition not concurrent. They couldn't have been witnessed at the same time since one year followed another. But these two hairs had to exist at the same time in order to establish the matter. And if these two witnesses saw one hair and these two witnesses saw another hair, one from the front, one from the back, we don't know if the two hairs were on her at the same time. And that's why it's only half a matter, and we have not established that she is an adult, and we cannot combine those testimonies. But that's distinguished from this case of the guy who resided on this field and farmed it for 3 years, because there's no need to establish that all three of them saw him at the same time, because what we're trying to establish is the guy was there for 3 years. And we have witnesses for each of the 3 years, even though they are three separate pairs of witnesses. New subject. In a related matter, Rav Yehuda says, if two witnesses testify that a person had worked and profited from a field for 3 years, okay? Two witnesses say this guy was residing on that field and working on it and benefiting from it for 3 years. But one witness says that while he was there for 3 years, this guy consumed wheat from the field. And the other witness says that while he was there working for 3 years, he consumed barley. So the testimonies don't quite line up. One of the witnesses says he was farming and eating barley. The other one says he was farming and eating wheat. Do we say that they contradict each other and therefore we have not established that this person was farming the land for 3 years? Or do we say that the difference between wheat and barley to the casual observer is not significant? And in fact, it's the latter. That difference is not significant. So one witness says he consumed wheat from the field. The other witness says he consumed barley from it. This is nevertheless sufficient for establishing the presumption of ownership. Rav Nachman objects to this ruling. If that is so, then even if one witness says he worked and profited from the field during the first, third, and fifth years, and the other witness says he worked and profited from it during the second, fourth, and sixth years, would you also say that this is sufficient for establishing the presumption of ownership? What is the difference between testifying about different crops and testifying about different years? And the answer is going to be, from the casual observer's point of view, whether he's farming wheat or barley, it's hard to tell. Maybe, the person just made a quick assessment while he was walking by. It's not significant because we all agree that he was residing on the farm, in that farm or working that field for 3 years. It doesn't really matter what he was growing there. On the other hand, if one witness says, I saw him during the first, third, and fifth years, and the other witness says, I saw him working there during the second, fourth, and sixth years, can we combine their testimonies? No, because in any particular year, there were not two witnesses to the fact that the guy was working on that field. Rav Yehuda said to him, how can you compare these cases? There in your example with regard to the year about which one master is testifying, the other master is not testifying about it. There's only one witness in each of those years. What is there to say that there is a contradiction in their testimonies between wheat and barley? It does not enter people's minds to note this distinction. Two witnesses did, however, testify that he worked and profited from the field for 3 years. And that's why we allow that slight contradiction in testimonies, but we don't combine the testimonies where there was only one witness to this guy farming there in any particular year. New subject. The Mishnah teaches that if the testimony was given by 3 brothers, each of whom testified about 1 year, and another unrelated individual joined with each of the brothers as the second witness, and that unrelated individual was there for all 3 years, then we have 3 distinct testimonies, and they are accepted by the court. But they are considered one testimony for the purpose of rendering them as conspiring witnesses. You might have thought, since we're saying that each of the years is a separate testimony, and that's why we're going to allow 3 brothers to have their testimonies joined, because they're separate testimonies, then shouldn't we say that for the purpose of conspiring witnesses, we have to establish that there was conspiracy in each of the 3 years and not call this one extended period of conspiracy? Now we're on page 57a. Now the Gemara relates there was a certain document that had the signatures of 2 individuals on it. One of the signatory witnesses died, and when the court sought to ratify the document, which requires either that the witness personally attest that this is my signature, or if he's unavailable, that other witnesses come and say, yes, we recognize that signature. That is the signature of the witness who purports, whose signature is purported to be on that contract. So that's how we would ratify this document. So there was a case like this, right? There was a document, a legal document that became the subject of litigation. One of the witnesses came back and said, that's my signature. The other witness had died. And then they brought in 2 witnesses to ratify the signature. Here's the wrinkle. One of the signatory witnesses died, and when the court sought to ratify the document, which requires either the witnesses personally attest to the validity of their signatures or that 2 other witnesses attest to the validity of the signatures, the brother of the witness who remained alive and one other unrelated individual came to testify with regard to the signature of that second witness who had died in the meantime, while the living witness attested to his own signature. So Ravina thought to say that this case is the same as the law of our Mishnah, which states that if testimony was given by 3 brothers, each of whom testify about 1 year of residency, and another unrelated individual joined with each of the brothers as the second witness, so these are considered to be 3 distinct testimonies. Similarly, in this case, one brother attests to his own signature, while the other brother joins with an unrelated third party simply to attest to the validity of the signature of the dead witness. Now, Rav Ashi said to Ravina, these cases are not comparable. There, in the case of testifying about the guy being on the property for 3 years, the property less 1/4, meaning 3/4 of the property in question, is not removed from the possession of the prior owner based upon the testimony of brothers, because each brother provided only half of the testimony for each year about which he testifies. But here in the case of the document, the property, 3/4 of the property is removed from the possession of the debtor, detailed in the document, based upon the testimony of brothers. Since one brother attests to his own signature, which constitutes half of the testimony, while his brother is half of the testimony to authenticate the remaining signature, you have a case where 3/4 of the testimony is coming from 2 brothers. And based on the fact that the majority of the evidence is coming from 2 brothers, we cannot remove the field from its owner. right? Since we'd be removing it from the status quo based on testimony, 3/4 of which originates with two brothers, it's a different case. And therefore, we don't accept the testimony of two brothers here. What they're going to have to do is find another witness who recognizes the signature of the dead witness to join with the unrelated third party. And then they could ratify the document and remove the land from the defendant. And that concludes our discussion of Mishnah number 5 here in chapter 3 of Tractate Bava Basra. Now, Mishnah number 6. These are uses of property that have the means to establish the presumption of ownership, and these are uses of property that do not have the means to establish the presumption of ownership, right? We said that if the guy is farming the land for 3 years, or if he's residing on it, or if he's renting out the property and collecting the rent, these would all be ways of establishing that he, had possession of it for 3 years. Now we'll look at some cases where the action works and some cases where the action does not work to establish the presumption of ownership. So if one would stand an animal in a courtyard, or if one would place an oven, a millstone, or a stove there, or if one raises chickens in a courtyard, or he places his fertilizer in a courtyard, these actions are not sufficient to establish the presumption of ownership. He's just using it for some storage. He's not really enhancing the property or benefiting from it in the same way as somebody who's farming it. But if one constructed a partition, a fence, 10 handbreadths high to contain his animal, and similarly if he constructed a partition for his oven, and similarly if he constructed a partition for his stove, and similarly if he constructed a partition for his millstone, or if he brought chickens into the house, or if he fashioned a place in the ground for his fertilizer that is 3 handbreadths deep, or 3 handbreadths high, these actions are sufficient to establish the presumption of ownership. As you can see, he's altering the land in some way, or in the case of bringing chickens into a house, well, he brings chickens into a house, only an owner of a house would permit that, because the chickens will do damage to the interior of a house. Now, that was Mishnah number 6. Let's get into the Gemara. The Gemara asks, what is different in the first clause, where having an animal stand in his courtyard is not sufficient to establish the presumption of ownership? And what is different in the latter clause, where constructing a partition is sufficient to establish the presumption of ownership? So Ula says, with regard to any act which, if one were to perform it on ownerless property, as we've discussed many times, for example, the property of a convert who died without heirs, which means that his land became ownerless, and then the first one who came along could claim it. But as we saw, it's not enough to say, this land is mine. He has to enhance it, or alter it, or fence it in, or make a breach, or irrigate it, or bring water, etc. He's got to take an action that improves the property. So now they're saying the same kinds of action by which you acquire ownerless property are the kinds of action by which you can establish a presumption of ownership if you were doing that for 3 years continuously. Conversely, any act that if one were to perform it on the property of the convert who died without heirs, and he would not acquire such a property, that same act is also not sufficient to acquire the property of another, where we would say that there's a presumption of ownership if he did it for 3 years. There's an interesting misprint in the Koran where they left out the word not. But if you're in the art scroll, I assume it's correct. Now, Rav Sheshes objects to this explanation. And is this an established principle? But there is plowing, which, if performed on the property of a convert who died without heirs, one acquires it. But if performed on the property of another, one does not acquire it. And additionally, there is consumption of produce for the duration of 3 years, which, if performed on the property of another, acquires it by establishing the presumption of ownership. But if performed on the property of a convert who died without heirs, one does not acquire it. So it seems like the rules are different. How can you say that the rules are the same for these two areas of the law? These cases contradict Ula's claim that the modes of acquisition to establish presumption of ownership against a claim by another person versus to acquire land that had been rendered ownerless when a convert died without heirs, they're not the same. It seems like there are differences in those areas of the law. So rather, Rav Nachman said that Rabba bar Avus said, now we're on page 57b, here we are dealing with a courtyard belonging to partners, right? So this we haven't been talking about in a bunch of weeks, but this is where we started earlier in our tractate, that if partners own a courtyard, one of them can seek to divide it into two courtyards. Sometimes he can force that on his partners, sometimes he can't. But until they divide it, so they each have the full run of the courtyard. Once they divide it, okay, so that's his half of the courtyard, and that's his half of the courtyard. And if they go make use of the other half, they're trespassing because they have divided it into two separate properties. If they haven't divided it, then they co-own it, and they each have the right to use all of it. So let's see how that applies here. So Rav Nachman said that Rabba bar Avu said, here we are dealing with a courtyard belonging to partners, where they are not particular with regard to the mere placing of items in the courtyard, but they are particular with regard to the construction of a partition. So the presumption of ownership is established only where the lack of protest indicates that the prior owner concedes that the property is no longer his. The co-owner's silence in the face of his partner using the courtyard for a temporary purpose does not indicate a concession, but silence in the face of one who constructed a partition is a concession, right? If one of the two partners live there, and one of them builds a fence down the middle, and then the other one doesn't say anything for 3 years, so then for sure this property is now divided. He didn't object. It meant that he says, okay, that's your half, this is my half, and he agreed to it with his silence because he was silent about the matter for 3 years. Now the Gemara asks, and how can you say, sort of just running past it, that they are not particular with regard to the mere placing of items? Maybe don't say that. Actually, if somebody places items in a courtyard and the other one objects, it might be creating some kind of a presumption. Let us read. Didn't we learn in a Mishna, tractate Nidarim, partners who, through vows, prohibited themselves from deriving benefit from one another, are forbidden to enter into a courtyard jointly owned by them, since each one has a portion in it, and it would be considered a violation of one's vow if one were to benefit from any part of the other's property. Let's unpack that a little bit. Unless the Torah says that something is prohibited, so it's permitted. Right? I can eat apples. There's nothing wrong with me eating apples. All fruit is kosher. So I can eat an apple. If, Blinator, I was to take a vow and say that, I'm just teaching now, that apples are hereby prohibited to me because of this vow, so then the Torah says that if you take a vow, then you are going to have to be obligated by your vow. Because no one forced you to take the vow, and the sages really discourage anyone from rendering something that is permitted by God into something that is prohibited by your vow. You should not do that. But if you did it, so now you can't eat apples. You rendered them prohibited. And in order to get out of your vow, you'd have to go to a Torah authority and get that vow annulled, which can happen sometimes and other times not so easy. So here, one way of saying another kind of vow is that, Blinator, I could say, everything owned by, my friend over here, Henry, is hereby prohibited to me. I can never benefit from anything that Henry owns. I can't go in his house. I can't eat his food. I can't take a ride in his car. And now that has the strength of halacha. Now that is like a law because I rendered it prohibited to me through the words of my mouth when I swore that vow. I changed my reality because I opened my big mouth. Now, okay, how much am I really giving up? Okay, I can never benefit from Henry. It's not so terrible. But maybe I got mad at Henry and I said, I'm never going to benefit from anything of yours again. And I forgot that Henry and I co-own this courtyard. Well, if we co-own it, so then each of us has the right to be anywhere in that courtyard, to store things anywhere in that courtyard, because we both have the full run of it. It hasn't been divided, so we both have the rights to all of the courtyard. Since he has the rights to all of the courtyard, just like I do, but I've just said that I will not benefit from anything that belongs to Henry, now I've made it so that I can't enjoy the benefit of any part of my own courtyard, that I own half of it, because he has the ability to be in any part of it. So what about that? So this indicates that partners are particular, even with regard to passage through the field or courtyard, and all the more so are they particular with regard to placing animals or vessels in the field. Somewhat attenuated proof, but let's keep reading. So rather, Rav Nachman said that Rabba bar Avu said, here we are dealing with a fenced-in yard located behind a group of houses that is used to store items not in regular use, where they are not particular with regard to the mere placing of items, but are particular with regard to the construction of a partition. We co-own a warehouse, so we both have the right to store stuff in the warehouse. I don't really care where you store your stuff in the warehouse. I mean, if it turned out that you were filling 80% of the warehouse with your stuff and there was only room in 20% of the warehouse for my stuff, then I would object. But if we're more or less sharing it and we have the same more or less amount of stuff in there, it's not going to really matter. I mean, maybe we should get together and organize how we're going to store things in there. But we each have the right to use different parts of the warehouse. But if we co-own this warehouse, and then when I'm not, when I'm out of town, you go in, you put all your stuff on one half, you move my stuff to the other half, and then you build a wall between the two halves of the warehouse. So yeah, I would object to that if it was done without my knowledge and without me consulting with me. But if I came back, I saw the wall, I saw what you did, and I said, man, not a bad idea. And 3 years go by, so now that's two separate warehouses. It has been divided. I own this half, he owns that half, and now I can't put my stuff in his half, and he can't put his stuff in my half. So generally speaking, we're not so particular where we put stuff in a jointly owned warehouse, but each of us would be particular about whether a wall was built, and we would expect to be asked about that. Maybe we'd be silent because we agree with it, but maybe we'll object. And if we object, well, no, take down the wall. I didn't agree to that. Now, Rav Papa said this and that, i.e. the rulings of the Mishnah in Tractate Nedarim, as well as, right, so this idea of vowing not to benefit from something that belongs to him, that's the law that was in Tractate Nedarim, which is about vows, as well as the rulings of our Mishnah here, are stated with regard to a courtyard belonging to partners. And the reason for the difference in the rulings, that we are particular with respect to vows, but we're not so particular with just respect to monetary matters, is that there are those who are particular with regard to the other partner placing items in or passing through the courtyard, and then there are those who are not particular. Therefore, in the Mishnah here, which issues a ruling concerning monetary matters, the law is to be lenient, and it is assumed that the partner is not so particular about placing items in any particular spot of the courtyard, and the presumption of ownership could be established. But in the Mishnah Tractate Nedarim, in the law of vows, which issues a ruling concerning ritual matters, as opposed to monetary matters, there the law is stringent, so that we protect people from coming to violate a vow for which they would be liable to bring a sin offering when the temple is standing, or would need to make an atonement, right? When you violate a ritual matter, so then you've crossed God, and you're going to have to make an atonement for that. When you violate a monetary matter, okay, so you owe money to the plaintiff who might bring a case against you, but it's not as serious, as it were, in terms of your eternal life where you need atonement. Now, Ravina said, actually, partners are not particular about placing items in the courtyard. And in accordance with whose opinion is this Mishnah in Tractate Nedarim about vows? It is in accordance with the opinion of Rabbi Eliezer. As it is turned to Baraisa that Rabbi Eliezer says, Even negligible benefits ordinarily waived are forbidden in the case of one prohibited by a vow from deriving benefit from another. In other words, one prohibited by a vow may not derive any benefit from the other, even a benefit that people commonly are not particular about, and would allow others to enjoy without first receiving permission. Therefore, although people are ordinarily not particular about others passing through their property, according to the opinion of Rabbi Eliezer, one who is prohibited by a vow from deriving benefit from his partner is prohibited not only from placing things anywhere in that courtyard, but even from walking through the courtyard. It's just so little that you're asking from another person to walk through his courtyard. But if you are prohibited by a vow that you undertook not to benefit from his stuff, and we co-own the courtyard, now I can't even walk through it, according to Rabbi Eliezer. Now, Rabbi Yochanan says in the name of Rabbi Benah, partners may prevent each other from using their courtyard for any purpose except for washing laundry. Right? So you can say, I'm particular about, we co-own this courtyard. And it's not that you can place anything you want in this courtyard because you own it with me. You have to check with me if it's okay by me that you're going to store a pile of dirt there, or that you're going to store an old car there, or that you're going to store your Ferrari there, which is going to attract unwanted attention from the outside. No matter what you're going to put there, we have to both agree on it. So both have to agree on it. In case, no matter what you're going to do with it, with one exception. What is this exception? Partners may prevent each other from using their courtyard for any purpose except for washing laundry. You cannot prevent your partner from washing laundry in that courtyard. Why would that be? It's not really that there's two couples who share this courtyard. It's not really that the man is saying, I can't prevent the other guy from doing laundry in the courtyard, because especially in this traditional ancient society, men didn't do laundry, women did laundry. And you cannot prevent any woman who lives in that courtyard or around that courtyard from doing her laundry in that courtyard. Everyone has a right to do laundry in that courtyard. Why is that? Because if you said, I don't want laundry being done in that courtyard, my wife won't do it and your wife won't do it either. So then where are they going to do it? They would have to do it not in the courtyard, which means they would do it outside the building, which is a public place. And why is that bad? Because when women do laundry in the ancient world, they lift their skirts. And you could see a little bit of their skin, which is immodest. And you can't force a woman to have to be in a compromised, immodest position. So for her sake and her privacy and her modesty, you are not permitted to say to your partner, hey, your wife can't do laundry there. My wife won't do laundry there. I object to anybody doing laundry in that courtyard. You can't say that. And the Gemara explains, partners may prevent each other from using the courtyard for any purpose without their permission, except for washing laundry. And this is because it is not the way of Jewish women to be degraded over washing laundry by laundering their clothing in a public area. Therefore, they must be allowed to launder in the courtyard. I'm almost done. Questions or comments, please get them in now. In connection with the matter of laundry being washed in public, the Gemara quotes the homiletic interpretation of a verse. This is from Isaiah 33:15. He that walks righteously and speaks uprightly, he that despises the gain of oppressions, that shakes his hands from holding of bribes, that stops his ears from hearing of blood, and shuts his eyes from looking upon evil. Right? So this is a righteous person, one who distances himself from any kind of inappropriate, possible transgression. And it's this last part of that verse that we're talking about, one who shuts his eyes from looking upon evil. Rabbi Chia bar Abba says this is referring to one who does not gaze at women while they are standing over the laundry, as it was common for them to stand in the water and raise the hems of their garments while laundering their clothing. And the Gemara clarifies what are the circumstances if it is referring to a case where there is another way by which the one walking could reach his destination. Then one who walks past the women, consequently placing himself in a situation where he will be tempted to gaze at them, he is wicked. Alternatively, if it is referring to a case where there is no other way by which he can reach his destination, well, then he is a victim of circumstance. So why is he required to shut his eyes? And the Gemara explains, actually, this is referring to a case where there is no other way by which he can reach his destination. And even so, he is required to compel himself to avoid gazing at the women. My friends, a person who wants to behave in an upright manner, who finds himself walking past, let's say, a river where women are doing laundry, right? And they've kind of like lifted up their skirts a little bit, like so their calves are showing. Maybe their knees are showing, that kind of a thing. And he's going to be tempted to look at that. And he should not do that. He should avoid looking at these women who they don't want their legs being looked at. They had to lift the skirt a little bit to do the laundry, but they don't want to be looked at. They're modest women. How much more and how much more difficult is it in the society that we live in? My gosh, you drive around LA. I mean, and I'm sure LA is the same as every other city, especially in the summer. Everywhere you look, it's crazy. Women in bikinis and lingerie on billboards, people walking down the street, etc. Now, that's not saying that the women shouldn't dress that way. I'm not commenting on that. I'm just saying that if you want to be a righteous guy, you really have to guard your eyes. And it's the male gaze. It's just very natural for guys to want to look. We're wired that way. So it really is something to, it's a very righteous thing for a guy to say, you know what, I got to train myself not to look at that because it's not for me. God willing, a man is married, that gaze, those eyes, that kind of looking, it's for his wife and not for everybody else. And that's what we're learning right there. Okay, let's look at some questions. Bill, if one is actually given... Wait a minute. What are we talking about? Lashes. I think that's yesterday's page, right? We're at 50. Yeah, that's from yesterday's page. Hold on. Let me reload the questions. What's going on here? These are not today questions, right? What's going on here? We didn't talk about lashes today, did we? Was this today? I think it is today. All right, let me see. Oh, we're talking about lashes in the case of conspiring witnesses. Gotcha. Okay. So if one is actually to be given lashes, one must not only have been found guilty of committing the offense, but also you must have been warned in the presence of witnesses that your action would make you liable to lashes. And right before you did it, too. So, do the conspiring witnesses need to be warned that if they conspire, they'll be liable to whatever fate they were planning for the defendant, or do they forfeit that protection due to the nature of their conspiracy? I'm like 99.9% sure that they waived that right to be warned. That's just the nature, because the Torah says so, right? The Torah says so. In terms of receiving that warning, I'm not sure that is spelled out in the Torah. That might be rabbinic. But the Torah does say that one, is found to be a conspiring witness will receive the punishment that would have gone to the defendant, but for that, because of his lying conspiratorial testimony. So I think he waives that protection. Great question. Joe, when people receive a death penalty, lashes or such, who is designated to carry the sentence out on behalf of the community? There's a lot of... We're going to be learning a lot more about that in Tractate Sanhedrin. For example, in the culture, and I guess, according to Christianity, there's this saying, right? He is without sin, let him cast the first stone. And you think, well, that's referring to stoning. But stoning is not throwing rocks at a person, right? Stoning is actually being thrown off a cliff. I mean, it's a death penalty, but it's actually being thrown off a cliff. So, it doesn't take the whole town to throw the person off a cliff. The question is it an agent of the court who acts as the executioner? Or are we going to say, there is somewhere in the Torah, that the witness actually has to be involved in carrying out the penalty, but that's usually not the case. There's definitely a lot of nuance to this, and we will come back around to this question when we get to Tractate Sanhedrin, which is definitely one of the most fascinating tractates when we get to it. And Joel, if two witnesses say that I lived and worked in a house for 3 years, and two more witnesses say that the first witnesses lie, then even two more say that the second witnesses lie. Then what happens? That the ones who are rendering the conspiracy, there's two witnesses who come and say something, two more come and say, no, you guys are lying, you couldn't have been there because we saw you somewhere else. And then it turns out that probably the original witnesses were telling the truth. The second pair of witnesses who came to render them conspiring witnesses, those are the conspiring witnesses. And we prove that by bringing in a third pair of witnesses. We have covered that case, and my understanding is that second pair, they will now be liable for the punishment that the first pair would have received if they had been established as conspiring witnesses. We pass along that kind of liability, which I think is what we would expect. That's what I've got for us today, and with God's help, we'll be together again tomorrow, Friday at the regular Friday time, noon Pacific. Have a great